is blamed for a dog getting poisoned, but the tenants may have broken the rules themselves. Mr. Singer and Ms. Clark came before Judge Judy seeking compensation for Harley's veterinary bills. They claimed their dog was poisoned by rat poison on the rental property. But Judge Judy quickly focused on a much bigger issue. The lease allowed only one medium-sized dog, yet the plaintiffs admitted they had 3 dogs. And that wasn't the only lease violation. Mr. Singer also admitted that he cut a hole into the door to install a doggy door without authorization from the landlord. The landlord had already taken professional measures to control rats, and the tenants were informed about where the traps had been placed. So Judge Judy had a critical question. If the tenants knew the traps were there, and their unauthorized doggy door allowed the dogs to roam freely, should the landlord really be responsible for Harley's medical expenses? This courtroom dispute was about much more than a veterinary bill. It was about responsibility and whether the plaintiff's own actions contributed to what happened. The plaintiffs believed they had a strong case. Their dog, Harley, needed veterinary treatment, and they wanted the former landlord to pay the bills. But Judge Judy wasn't simply interested in what happened to the dog. She wanted to know how it happened and who was actually responsible. The landlord had hired professionals to deal with a rat problem, and traps had been placed around the property. The plaintiffs were reportedly informed about the locations of those traps, but despite that, they had installed a doggy door by cutting into a door, something the lease did not authorize. Even more importantly, the lease permitted only one medium-sized dog. The plaintiffs had 3. That meant their dogs had greater access to the property, despite the tenants knowing that rat control measures were in place. Judge Judy's questioning put the plaintiffs in a difficult position. They were asking the landlord to pay for Harley's veterinary expenses, but their own admissions raised serious questions about whether they had followed the lease and whether they had taken reasonable precautions to protect their pets. And at a glance, this looked like a simple landlord dispute. A dog was allegedly exposed to poison, veterinary bills followed, and the tenants wanted compensation. But once Judge Judy started examining the details, the situation became much more complicated. The plaintiffs admitted that they had 3 dogs, even though their lease allowed only one medium-sized dog. Then came another admission. Mr. Singer had cut a hole in the door and installed a doggy door so the animals could move in and out, but the landlord had not authorized that alteration. At the same time, professional pest control measures had been put in place to deal with rats, and the tenants had been told where the traps were located. That created a major question of responsibility. If you know there are rat control devices around a property, but you create an opening that allows your pets to freely roam, can you later hold the landlord responsible if something happens? That's exactly the issue Judge Judy was trying to unravel. The case wasn't simply about Harley's veterinary bills. It was about whether the plaintiffs had taken responsibility for their own choices and whether the evidence actually supported making the landlord pay.